and gentlemen, and welcome back to another What If session. My name is Viapia, and as always, it is fantastic to have you. Today's topic is polygraph tests. We are going to unpack the admissibility of polygraph tests, the weight that can be attached to tests, and general considerations that employers need to consider or take into account when considering polygraph testing. Now, polygraph tests are useful as part of your preliminary investigation where you establish whether misconduct took place. Now, if you, as the employer, obviously have prima facie evidence that an employee was involved in a dishonesty-related transgression, for example, there is no doubt that the employer has grounds to expect the employee to undergo a polygraph test. Now, although the admissibility of polygraph testing has been a contentious issue, in terms of our case law, it is clear that polygraph tests are admissible. In other words, it can be admitted as evidence. However, it carries little evidentiary value on its own. In other words, you can only use it as supporting evidence. If you want to introduce polygraph results in evidence in the disciplinary hearing, for example, please consider the following guidelines. 1. The test should be used scientifically. 2. The test should be verified, and the examiner conducting the test should be trained and must also be a member of the South African Polygraph Association. Before conducting the test, you must always obtain the permission from those being tested. Test results cannot be the deciding factor when it comes to the evaluation of evidence to determine an employee's guilt, and also there should be a minimum invasion of privacy. In terms of the disclosure of the results, it should, as far as possible, be limited to those who have participated in the test. Usually, if we consider a polygraph test in the workplace, it is the employer that is entitled to see the results, as well as the employee who was requested to undergo the test. Now, because little weight is attached to the results of a polygraph test, it is essential that other evidence of the employee's probable involvement be led during a disciplinary hearing. In other words, the test results should be supported by other evidence corroborating and supporting the results of the test itself. Now, the examiner may have to be called in person to testify if there is any dispute about the test or its results. The examiner may be called to come in to testify about his or her qualification, how the test works, how the result works, etc. Ideally, in your disciplinary code, you would want to write in that testing could be used. So ideally, you would want a clause that governs or that regulates polygraph testing in your disciplinary code. Now, in terms of general procedural guidelines for testing, there are 3 phases or distinct phases in the testing procedure. 1, we have the pre-test. 2, we have the testing phase. And 3, we have the post-test phase. Now, in terms of American legislation, which should be supported in our view, the following guidelines apply. So during the first phase, which is the pre-test phase, the employer must provide the employee with adequate notice of the time and place of examination. The employee must be informed of his or her right to obtain legal advice or to consult with a legal practitioner during each phase of the test. The nature of the test and the polygraph instrument must be explained to the employee. Both parties in the polygraph test or during the test have the right to record the test with the consent of the other party, obviously. The employee must sign a notice that explains the legal rights of both parties. The employee must be informed that continued employment may not be made conditional upon taking the test. The employee must be informed that statements made in the examination may be used as a basis for adverse employment action, which may even include dismissal. The employee must also finally be provided with an opportunity to review all questions to be asked. So that is what we need to consider during the pre-test phase. If one considers the testing phase, it's important to note that the examiner may not ask any questions which have not been previously presented in writing to the employee during the pre-test phase, which we have just discussed. During the post-test phase, prior to taking any adverse employment action, taking disciplinary action for example, the employer must interview the employee regarding the results of the test, as well as the employee must be provided with a written copy of questions asked and any conclusions or opinions formed as a result of the responses to the question. In other words, a copy of the polygraph test result. Also important consideration is that an employer may not ask questions regarding religious beliefs, regarding political opinions, racial matters, trade union matters, or matters relating to sexual behavior during any of the 3 stages that we refer to. Questions may also not be asked that can be seen as harassing or unnecessarily intrusive or degrading. Now, the latest Labour Court case that dealt with polygraph testing is the Faru versus the Premier Food or the Blue Ribbon case. And in this case, the court held the following. In the context of a disciplinary process, the polygraph can be a useful tool in the investigation process. So that's what I referred to in my opening line. It is a useful tool during the investigation process, but it can never substitute the need for a disciplinary hearing. Right? So that was the first thing the court said. The court also said that a polygraph test on its own cannot be used to determine the guilt of an employee. And in the context of an arbitration, which we can also probably assume can include a disciplinary hearing, the results of the polygraph may be taken into account where other supporting evidence is available. In other words, we cannot only consider the polygraph test alone. However, the court also mentioned that if there's any dispute in terms of the polygraph test, that the qualifications of the person who conducted the test must be known, and that the test was conducted or was done according to acceptable and recognizable standards. A question that is often asked is whether random polygraph testing can be done. Now, employers or employees may be lawfully required to submit themselves to random or even regular polygraph testing. However, a negative test result cannot by itself justify any action being taken against a particular employee in the absence of corroborating evidence that the employee had committed misconduct. Therefore, even if it may be lawfully required of employees to submit themselves to polygraph tests, in the absence of evidence of possible wrongdoing, the taking of the action against such an employee will in all probability be held to be unfair, unless obviously you have corroborating evidence of this misconduct or possible wrongdoing. Now, the situation would be different if an employee against whom prima facie evidence of wrongdoing exists refuses to undergo a test, because the test could potentially exonerate him or her. Now, if you have followed as the employer or as the person conducting the test all the guidelines and considerations that we have discussed earlier, the refusal by the employee to take the test may justify a negative inference to be drawn against the employee based on such refusal. Ladies and gentlemen, that brings us to the end of this what if topic. Any questions in this regard, please do not hesitate to contact us. Be on the lookout for our next invite. It will probably be in 2 weeks' time, but until then, all the best and goodbye.